All summer, we have been talking about how powers of attorney are a way less expensive option than a guardianship or conservatorship case. Um, Guardianship and conservatorship hearings can cost upwards of $10,000. I know we charge for a conservatorship just under $5,000 for the whole hearing, and getting everything involved. However, we charge somewhere between $400 and $700 for a set of powers of attorney, your general power of attorney that helps out with legal and financial decisions, and your healthcare power of attorney that helps out with your healthcare decisions. Um, by the way, everybody, I'm Dinesh Chawla, estate planning, elder law, and probate attorney with Chawla Legal Group. So again, you'll hear a lot of attorneys talk about the burden difference, the cost difference, all of these differences between having a power of attorney in place and having to go to a guardianship or conservatorship hearing. And that's all well and good. We've been taking the same approach. However, one approach that we take in our workshops is a more personal approach. So I'm going to share this story with everybody right now. And this is what the healthcare power of attorney particularly means to me. So I'm going to share my screen really quick. This is a picture of my mom and dad. And this is why healthcare power of attorneys are so important. Um, the day after Christmas, December 26th of 2019, my mom passed away. When we were sitting in her ICU area of the emergency room at the U of M hospital on the night of Christmas Day, December 25th, I remember it was right before midnight, around 11:40-ish. And my dad, my sister, and I were kind of beating around the bush on the topic of what happens if we have to make a decision to take my mom off of life support. And I could tell, obviously, that that decision was weighing on my dad as her agent under her healthcare power of attorney. He was going to have to tell the one, he was going to have to be the one to tell the doctors to take his wife off of life support. As we were kicking around our thoughts on everything, and there were some disagreements, but as we were talking about all of this as a family, the doctor came over. And she said she had reviewed the power of attorney. She had reviewed my mom's case. And she had talked to some other doctors, and they have a plan of action. She said that the plan of action had 4 stops along the way for most people. There was a first stop, and if that didn't work, and there was a second stop, that didn't work, third stop. And if that didn't work, then there was a 4th stop. To get to the 4th stop took 3 trial and error. And she said, the doctor, she said that we have about 6 hours, 6 to 7 hours to see if these 3 things will work. If they don't, we're taking her off life support because she said in her power of attorney that she never wanted to be on a ventilator again. So we're honoring that. The 4th course of treatment that we possibly could have given her to keep her alive includes putting her on a ventilator. It is her wishes that she doesn't want to be on a ventilator. So as soon as we get to that course of treatment option, if we do get there, we are going to not do that treatment and sign a do not resuscitate order. That was the trigger in my mind that we only had about a day left with my mom. Made us all sad. However, it made my dad feel at the time a little relief. It didn't strike me at the time, but now it does, that that statement in her power of attorney saved her husband from having to make a decision that he didn't want to have to make, and that would have weighed on him for the rest of his life. She made that decision for us because in 2013, she had a really bad fungal infection in her lungs from pneumonia, and they put her on a ventilator for about a month. And she said she never wanted to be on a ventilator again. She didn't know that she could put that specific option into her power of attorney document. She didn't know that she had that ability until she went to a very good estate planning attorney. There are certain things that I would say you can do yourself in life. There are certain things that I would say seek professional advice. Had we not had that professional advice, my dad would have had to make a very tough decision. But because we did have that professional advice, my mom was able to take my dad off the hook for that decision. And that's something that I can tell in my dad's emotional health now. He doesn't have that weighing on him. There's no, what if we did this? What if we did that? We don't have to worry about that anymore because mom was able to make that decision. She was able to keep that control through the power of attorney. So, yes, there's a huge cost advantage to having a power of attorney versus going through the probate court with a guardianship or conservatorship hearing. Yes, there are burden and time and other benefits, cost benefits to getting the powers of attorney in place versus going to court for a guardianship or conservatorship hearing. The bottom line is there's a more human side to it as well. It's not just about the dollar cost or the time cost or anything like that. It's about the emotional cost and the cost savings that my dad now has. So I'm Dinesh Chawla, estate planning, elder law, and probate attorney with Chawla Legal Group. And that's what powers of attorney, especially the healthcare power of attorney, mean to me. If you think this was useful and you like what you saw on our YouTube page, please subscribe. There's a button down there somewhere. Click it and subscribe for more of these. Thanks.